LLC. Docket number 2016-125. Representing the appellant, Town of New Haven, is Cindy Hill. Seated at council table with Attorney Hill is Doug Tolles. Representing the appellee, New Haven GLC Solar, is Leslie Cadwell. Seated at council table with Attorney Cadwell is Sam Carlson.
Okay, thank you. Council.
Thank you. Good morning, Mr. Chief Justice and Justices. May it please the court. I am Cindy Hill, and it's my honor here to represent the Town of New Haven. As the clerk stated with me, is Doug Tolles of the New Haven Select Board representing my client. We're here on an appeal from a final order of the Public Service Board regarding a 500 kilowatt net zero solar array proposal by the appellee New Haven GLC Solar. And as you have seen from the briefs, our issues are primarily ones of procedure of the Public Service Board process. We were denied a hearing in that process after an extensive time period of documents going back and forth. And the town submitted numerous filings, and each one of those filings was in response to amended filings of the petitioner appellee changing their project.
As I understand it, though, the changes were only with respect to this question of access roads. Am I right about that?
The first major change was in regards to, yes, the access roads and the access road, but the first change was that the access road was moved to a different parcel of land. That parcel of land and that host landowner are never identified in the application by name. There's no host, they're required to identify the host landowner. That host landowner was never identified.
But the landowner wound up agreeing to the change that was made?
That's not in the record. I have no idea. The landowner is not even named in the record, nor is the address. So there's no indicia of site control regarding that parcel.
So there's an email in the printed case, somebody's printed case. Maybe it's not in the record that you have, but I saw an email, copy of an email that indicated agreement.
Oh, this is in regards to the abutter to that new parcel. So 45-day notice was sent out on the main parcel. Then, when they filed with the petitioner filed with the Public Service Board, they added a new parcel on, and that's where the access road is going to be constructed. So now there's a new abutter to that new parcel, and they never notified that abutter. Eventually, at the end of October of 2015, under order from the Public Service Board of October 15th, on October 26th, they submitted an email saying that that new abutter had notice of the project and waived their right.
So I raised that when you started in because it seemed to me that what you were trying to do was take this issue of the access road as the reason why you didn't have to say anything during the time period allowed for comments about your main substantive objection, which is this is inconsistent with the plan. Why didn't you answer as to the plan right away? Because it's just a question about whether the plan covers this or not.
Justice Julie, we did in our 45-day notice comments, we commented extensively regarding the plan, and then our initial comments on this proposal were, when they filed with the Public Service Board, was to re-adopt our 45-day notice.
Your answer seems to be to reserve, to say things that were more procedural, as you said, and then say, well, once we have a chance to investigate, we'll give you a substantive response. And the substantive response was going to be, what that came was eventually about the plan, which seems to be the main issue in contention.
We reincorporated our 45-day notice comments and then said, as the Department of Public Service said, that what had been filed with the Public Service Board was different from what had been filed with the 45-day notice, and that we were in the process of having staff review that in order to submit other more specific comments. But right from the get-go in that, we notified that the application had not noticed the additional abutters as required by the rule and requested that it be found incomplete. Now, the Public Service Board we asked repeatedly that the application be deemed incomplete because they hadn't notified everyone required required to be noticed. And the Public Service Board never responded to that until October 15th, when they issued an order that it was not labeled deficiency notice, but it stated that the petition could not be processed further unless or until they filed a letter from the additional abutter saying that they had notice. So on October 15th, well after these other filings, they file what I would argue is effectively a deficiency notice saying we're not going to process this petition any further until you notify us that the appropriate people have been notified.
Let me go back to the plan question. Your main argument appears to be you should have gotten a hearing, technical and the public hearing. But it seems like the main issue is this question of the plans. How would a hearing have done anything with this? Either the plan, it would be a prohibition or a violation of the plan to allow us to go forward or not. How does a hearing have anything to do with that?
In regards to, there are several aspects of our plan and of orderly development that are implicated by this proposal. One is the town's energy plan component, which had the guidelines of a 300 kW facility, and we would have presented testimony regarding the reason for that. As suggested in our comments, that has to relate with both scale and not just aesthetics, but also the scale of development relative not only to our town, but we related it to buildings within the county. We also, in terms of the multiple...
That's a suggested limit in your plan, right? It's not stated stronger than that.
There is a package that is suggested in the plan. It says we suggest the following guidelines, and it was a 300 kW limit, but also that it be beneficial to the people of the town and be appropriately cited. And so those were scale parameters. Those are scale guidelines. And those guidelines have to do as well with size. One interesting thing, I note a number of findings of the Public Service Board's decision that are inconsistent with the record. The application said it's going to utilize less than 3 acres of the parcel, but the Public Service Board final order says it's going to use 5 acres of the parcel. Our 300 kW guideline has to do with scale and signs of development relative to other buildings within the area. But we also noted that this multiple driveways issue has to do with strip development and the town's very strong desire to limit the development on Route 7, which is a major state
I'm
road.
talking about these access points. This isn't a retail store. It's not a restaurant. It's none of that sort of stuff. The thing is built and put there. How often do these things get used? They're not available for public use. They're private, short private access points.
Well, you're talking, the original proposal in the 45-day notice was to use the residential driveway that serves the Russell Farm homestead that runs between the house and the farm. And Historic Press chimed in on that and didn't like it. It's a state registered property, state historic registered property. So this is when they moved the access driveway for construction and maintenance to the next parcel north, again, without identifying the landowner or the address. And that's not, the landowner and address aren't included in the final order of CPJ. So that would be I believe it's a 14-foot wide extension involving grading and gravel and so on. And then it has an AOT, they did file eventually at the end of October an AOT, or V-Trans, permit for that curb cut. They then revised, on September 8th, they filed another revised site plan that included yet another driveway, this time back again near the homestead, and the reference was to...
Can you clarify, it's near the homestead, but it's not the same path as original, is that right?
Correct, this isn't the residential driveway. I'm not exactly clear, it looks like it's just a few feet to the south of that where tractors sometimes go in. It was referenced as being an existing farm access, but we had submitted with our comments a Google Earth shot picture. There's really no obvious access there, so from their sketch, I'm not entirely clear where that's supposed to be. It looks like it's just south of the residential driveway where they started. So now we have a residential driveway, and that is also going to be widened, have gravel put in, I assume a culvert, I assume there's going to be a V-Trans permit of some sort. So now we have right at the homestead, a residential driveway and a commercial driveway, and then on the parcel north, another commercial driveway, both of which will involve gravel, grading, an access permit. You asked about what's the impact of this. In terms of how often trucks are going to go, I don't know. During construction, it will be extensive. After that, it's going to depend on what maintenance it needs.
But your characterization with this is this was a violation of plan restrictions on strip development.
Correct.
And when I think of strip development, as I say, I think of something that's available to the public, a store, a restaurant, or something, or a gas pumps, or something like that. This doesn't seem to fit to me at all within the idea of strip development. So that's why I ask you, well, how much access is in the biggest thing? It's a private roads, it's not public at all, but what's the access problem?
Well, one thing is that now you go into these multiple strings of curb cuts and driveways in a short stretch of Route 7. The other is what will happen to those parcels in the future. You now have a constructed commercial driveway, and what does that do to this parcel in the future? It's particularly our concern because that parcel, the access driveway parcel, is not named, the address isn't named, the host landowner isn't named. Let's put it this way, either it's part of this project, in which case the host landowner should be named, the parcel number should be named, and that way things like emergency access to the project and so on are able to know where the access is. Or it's not part of the project, in which case the town is going to regulate it, and it's going to need town fill permits, gravel permits, it's going to be considered land development and get a permit. So either it's part of this project, either it's an inherent part of this project, in which case the notice that did go out even to the adjoining landowner didn't list the host landowner and this address of this new aspect of the project, or it's not part of the project, in which case we're going to regulate it through town regulations, and if they start constructing it without those town permits, we're going to be moving to enforce it.
Is the special printing case, supplemental printing case, I think of it, Valley page 7, is this a right map of what this all is? That is where the solar array is, where the roads are, where the curb cuts are, and all of that?
I believe so. That's a supplemental case filed by Attorney
Yeah.
Campbell. Yes, that's correct.
This is the right order.
That's
Right.
the left.
And the one we're most concerned about is the one at the top or the one at the bottom? The top one goes into the solar array, the bottom one goes into something that is called the pull box.
So the top one is the one that's on a different parcel, that's not named in the CPG. The other one is the second one. The other one that's south of the Russell Farm Homestead was never mentioned in the final order in CPG. Was never mentioned in the final order in CPG at all. And that final order in CPG has a number of errors, as we pointed out in our brief. They got the wrong off-taker. They apparently ignored the filing of my sister counsel correcting the off-taker. They don't mention the other parcel. They don't mention this new filing with the second driveway that's down back near the Russell Farm property. And so and as I noted in the brief, they believe they mischaracterized the DPS filing. So those filings don't, and they also give the address as only being the Russell Farm address. They never mention the second parcel. They never mention the driveway south of the Russell Farm homestead. So for those reasons, for those deficiencies in their findings, I would ask that the matter be remanded, either that it be remanded for hearing, which would be our brothers, or that it be remanded for correction of all these findings that don't reflect accurately what the project location components are.
All right,
Thank you.
thank you, Council.
Good morning. May it please the court, I'm Leslie Cadwell. I represent New Haven GLC Solar. Sam Carlson, principal of New Haven GLC Solar, is here with me today. The appellee's brief addressed all of the reasons why the board's order should be affirmed on appeal. I'm going to rely on the brief and just raise a couple of to assist the court in sifting through some of the materials. I'd like to first address a couple of issues that just came up in response to Attorney Hill's argument. First, with respect to the town plan, the standard is whether, or the standard that the board has to apply is to give due consideration to the land conservation measures and the recommendations of the town. The land conservation measures in a town plan don't necessarily include everything in the town plan. They are measures that are intended to preserve and conserve land. With respect to the town of New Haven's guidelines on energy, on the size of energy facilities, on whether the energy facility needs to benefit the town residents, I submit that those are not land conservation measures. Those are guidelines for how the town would like to see its own energy needs fulfilled, and the town can certainly pursue those. The board does not have to give those due consideration, although it did. You found that those plans.
Excuse me, what do you think that due consideration means after the Rutland removal case?
Well, I think in this case, and in any case, the board has to actually look at the town plan, evaluate whether the land conservation measures apply to the particular area where the project proponent is planning to go. If there is nothing in the town plan that addresses that particular parcel or that area, the board has given the town plan due consideration.
Although in Rutland Renewable, the board actually went through the exercise of having a hearing, and the town had an opportunity to present a fair amount of evidence about why the plan said what it said, and what the town intended by the plan. And in this case, the board purported to interpret the plan on its face without giving the town that opportunity. Is that due consideration?
Absolutely. I don't think that there's anything else that the board needed. The town plan stands on its own. The difference between the Rutland Renewable case and this case is the different types of projects and the statutory regime that governs them. On the Rutland Renewable case, they had to have a hearing. You can't waive a technical hearing under Section 248 unless you proceed under Section 248J or you proceed under a net metering statute. So there was no hearing required, and the board has issued thousands, literally thousands of certificates of public good without hearings.
Can I ask you about, I'm sort of struggling with these timing requirements and the interplay between the timing requirements and the reality that these applications by design are going to evolve as more information and comments come in. So I understand your position that the fact that the proposal changed in some regard between the 45-day notice and the actual application doesn't mean that you have to redo a 45-day notice unless it meets whatever the substantial changes in this one. What I'm trying to figure out is you then have 21 days for a certain group of people to respond. And when you have new information or changes that come along, so in this case we had the 9/3, the September 3rd filing, added the second drive-in, and I think that was the first time the interconnection stuff came up. Is it your position that notwithstanding the fact that there's only 21 days, if on day 18 or 19 of the 21 days something new comes into the application, all those other people have just 1 or 2 days to respond to the new stuff? There's no additional time?
It's really up to the board's discretion, and in this case, the board allowed additional, they took no action, and there were additional filings. Whether the board has to consider them or not, I think depends on whether those changes are substantial or not, under the board's own precedent. And here, the town did have an opportunity. The board found that the changes were not substantial, and so there was nothing in the town's comments in reply to that suggested to the board that they should change their mind.
But come back to the hearing or the comment for it. You took the position that the statute that governs, I think it was 248J, and said the board doesn't have to hold a hearing. The appellant's view is that's not the governing statute, it's the net metering statute, and the net metering statute is not written the same way, and the net metering statute does not allow net metering.
Thank you for that question, Justice Dooley. I think the town misconstrued my brief. The appellate's brief explains, in response to an assertion in the appellate's brief, that Section 248 requires a hearing in all cases. I used Section 248J as an example that Section 248, in fact, does not require a hearing in all cases. The legislature provided for a waiver of hearing for certain projects that really don't require them because they don't raise significant issues, they don't have significant impacts. And so the Section 248J really was to demonstrate that 248 doesn't require a hearing in all cases. The net metering statute, the legislature granted the board the authority and the discretion to adjust the hearing requirements in Section 248 as it saw fit. And that regime has been in place since 1999.
So let's go back to the hearing thing. So let's say that the appellant is right, that they submitted their comments in time because of all this movement about the access drives, and their comments could be about anything, not just about the access drives. Let's assume they're right. Does that mean the board has to hold a hearing, or is the board still can hold no hearing in your view?
I don't think the board has to hold a hearing. The board will
So
convene a
you don't
hearing
think the board ever has to hold a hearing, as I take it as you agree?
only if the filing raises significant issues that would require the development of an evidentiary record. And the board has used that standard for decades under Section 248J.
So the town wanted to put an evidentiary record on the meaning of the plan, what it would do to the town, all that general concern that this was inconsistent for a rural town to hold a large solar site. Why don't they get a hearing on that?
Well, I would disagree with your characterization of a net metering project being a large solar site. They are by definition small. The legislature has deemed them to be small and allowed the board to do it.
Obviously, I was using large in relation to what they thought was an appropriate solar site for the town, or at least the suggestion of what they thought was the solar site for the town.
I think if the board believes that the development of an evidentiary record would help it exercise its discretion in these cases, it would hold a hearing. I don't think that just raising an issue, asking to present evidence without it rising to the level of a significant issue requires a hearing. That's in the rule. It's the standard that the board has applied. Practitioners before the board need to understand what this means. I don't think the board would want to clog up, just like this court, have 5 justices sit on every single case. If every single case didn't warrant all 5 justices to sit, I think the Public Service Board has the same kind of discretion to convene hearing if it feels it's warranted, because the legislature has expressly authorized it to waive hearings for cases like this.
And that standard is true whether it's a technical hearing or a public hearing.
There is no requirement for a public hearing in anything other than a Section 248 that arises outside of 248J or the net metering statute. There's nothing in
Big
the...
project.
Could you tell me,
Those are big projects.
Correct.
just so I have try to get a mental picture of what is proposed, it is a 5-acre project, right?
More or less.
More or less, okay. How many panels, how many solar panels do you put on a more or less 5-acre project?
Well, the answer, you have to ask an electrical engineer.
Well, don't you have it in your proposal? Isn't it part of what you propose, or is it?
Well, no. So the board, the number of panels doesn't necessarily correlate to the size of the project, and that's because the panels can have different capacities. So you can have different size panels, you can have different capacity panels. The board has actually held that a change in number of panels or the change in capacity of panels, as long as it doesn't change the footprint or the overall capacity, is not a significant issue. Very early on in net metering cases, developers would file the exact equipment. That exact equipment, sometimes by the time they go to construction, isn't available anymore. So you have to find some substitute, and as long as the project doesn't have an impact on any of the Section 248B criteria that are related. So for example, let me take the panels. If a change in the panels would increase the capacity of the system, that would be a substantial change depending on the increase. It could be, maybe 0.05 kilowatts, probably not substantial. A 100 kilowatt, it would be substantial. If the change in panels meant that you were going to use 19 acres as opposed to 5 acres, I would submit, if it were my client, I would advise go seek a CPG amendment. I think that's probably going to be considered a substantial change.
Can I know what you do?
Yeah, I guess that's it.
The interconnection question, okay? As I understand it, in the SSE New Haven Solar 2 LLC case, the fact that it failed criterion 3 of the fast-tracked interconnection review was, but I think everybody agreed it wasn't really going to be a problem. That created an issue, at least, a significant issue that warranted a hearing. As I understand it, this is sort of on all fours. It failed the fast-track analysis under the regs, yet the thought was it's not functionally going to be a problem. Why is it that a significant issue in this case?
Well, because the electrical engineer for the project testified under oath, submitted an affidavit that it wasn't going to be an issue.
And that's true, that wasn't true in the other case?
I don't know. I'm not familiar with all the facts of that case. I know that that case settled, and the board ultimately held in that case that this wasn't going to be an issue.
Does your position on the interconnection depend on us concluding that that provision in the procedural rules that allows the board to waive its rules also allows the board to waive substantive regulatory requirements?
So I have a couple of arguments on. One is I don't think the town has standing on this issue on appeal. They absolutely, anybody can comment about anything at the board. That's not an issue. The issue is whether they have any legal interest here on
And do
appeal.
we do separate analysis issue by issue? If the party has standing in a case, do we then parse it issue by issue to decide whether they can make an argument on appeal?
Well, I would think so, because you don't have, they have standing to appeal if they're aggrieved. They don't have standing to appeal just because they were a party. The statute says they have to be aggrieved. So if they're not aggrieved on an issue, then I would submit the court would have to analyze whether they have the right to raise issues.
Aggrieved on an issue or just aggrieved?
Well,
I mean, they can be aggrieved by the outcome. It sounds like you're suggesting we need to do an issue by issue analysis to decide whether a particular litigant is entitled to make a particular argument to us. I've never seen that in my time on the board.
well, I do think in this case, if you were to decide to reverse and remand on this issue, I don't know what legal right of the appellant that you would be vindicating, because they have no interest at all in the interconnection rule. They play absolutely no role. They have no statutory authority under Title 24 to provide for the welfare of the citizens because of actions of an electric company.
They have standing to challenge the CPG, and compliance with the interconnection rule is one component of CPG review, right?
No, not necessarily. Not necessarily. It is related to the system impact and system stability and reliability, but the interconnection piece is a completely separate process from the certificate of
Do I
public
understand that
process.
everybody else agreed on interconnection? Is that what the...
Yeah, so it was the electrical engineer for the project, the interconnecting utility, the Department of Public Service, which, unlike the town, is actually charged with supervising electric companies and the terms and conditions of interconnection. And the Public Service Board that has substantial experience and expertise in this area. The town does not and did not raise a significant issue. And in fact, the project will probably be constructed before this case is even done, and the interconnection will be done and proven to be reliable and work.
You said you had several arguments. One was the standing, and then I hung you up on that. Let's assume you lose on standing, and that issue is before us. Do we have to, in order to say that the board can essentially waive the regulatory requirement, do we have to conclude that it's got the discretion to waive any substantive regulatory requirement under that rule? Or is there
Well,
something
there's
else?
actually another rule, and I apologize for not citing it in my brief. It's 1.2. And that gives the board the authority to grant exceptions to any of its rules. So both 2.107 and 1.2 both give the board authority to waive its rules. The interconnection is a rule, and the board is allowed to waive it and has in many cases. Thank you. For all those reasons, please affirm the board's decision.
Appellant has a minute 15 remaining.
Thank you. Just very briefly, touching on a couple of points that were all, I feel, we've addressed in our reply brief anyway. In terms of, my sister council stated that the legislature has expressly authorized the PSB to waive hearings. I briefed that extensively and stated that they authorized them to modify the notice and briefing schedule. I think I quoted both Nan O'Brien and Justice Scalia in that portion of my argument regarding the meaning of the word modify, and we would read that the word modify does not mean that they can waive.
Odd, I take it, which is Ms. Kendall's argument now, would be odd to say the one about big projects you can waive the hearing, and not about not meeting.
On 248J, which she cited as evidence that hearings can be waived, this court has always held that these CPG hearings are effectively legislative, even though they run under the rules of civil procedure, and once a hearing is granted, they sort of take on a contested case status. 248J requires the projects proceeding under 248J to have public notice and a public comment period. So everyone in the public has notice and opportunity to comment, not just this tiny list that's notified of an effectively contested case type list. So there is a legislative notice and comment element under that statute. We also briefed the agreement in our reply brief in terms of the thank you.
Thanks very much.
The next hearing for the court will follow immediately.